Hello and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery Today's Doug Austin. It's the important eDiscovery case law decisions for January 2023. This is our 2023 kickoff, and our faculty experts returning, of course, Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the Counsel. This webinar will be recorded and available for replay at your convenience, as are all of our EDRM webinars. Kaylee Wallstead, EDRM Chief Strategy Officer, is here with us today. What do we have for resources today, Kaylee?
Well, thanks, Mary, and thanks to everyone for attending. This is always my favorite monthly webinar series. So buckle up, lots of good education, information, and entertainment as well. So if you look to the right of your console, you'll see a paperclip. That is where you can find the resources and attachments. So up first, be sure to save your seat for next month's important eDiscovery case law decisions for February. Next up, keep up with your eDiscovery news and education. Be sure to subscribe to eDiscovery Today. I start every day out reading what Doug has put out for us to learn from. You can also learn more about how Judge Peck can help and assist your organization. Learn more about Judge Peck at the link. One of my favorite blogs is Tom O'Connor's extra spicy Techno Gumbo blog. And you can subscribe and read some of Tom's wise wisdom there. And then up next on the EDRM webinar channel, January 25th, the Tom and Jeremy Show, episode 8. So be sure to join us for that. And back to you, Mary.
All right. Thanks, Kaylee. And you can download a certificate of attendance from the Counsel after your webinar to use for your continuing ed requirements. And our moderator, our curator of cases, Doug Austin. He is the founder and editor of EDRM Trusted Partner, eDiscovery Today. He's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug's published a daily blog since 2010 and has earned JD Super Awards 3 times. Tom O'Connor, hailing from the great city of New Orleans, for the last 3 decades plus, he has stewarded the Gulf Coast Legal Technology Center, has a wonderful YouTube channel for long form interviews, and he's a sought out consultant on some of the largest cases. He's written the book on eDiscovery for the rest of us, and he cooks a fabulous crawfish meal, I understand.
It is crawfish season.
It is indeed. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in Southern District of New York after 23 years, writing many of our first eDiscovery opinions, and then later some of our more pointed opinions, like why we don't use boilerplate objections anymore, why we need to use 502D orders, and technology-assisted review. All 3 of these gentlemen serve on the EDRM Global Advisory Council, and we are very, very grateful. And spending each month with us, going through at least 5 cases each month, we just can't thank you enough. So with that, Doug, you got some cases for us.
Indeed, Mary, and thanks. And thanks to everybody for attending. Honestly, we may have our most unique set of cases ever, as we're kind of batting cleanup, looking to cover a few cases from last year that we previously missed. So this time, the disputes include production of scanner data in an unpaid overtime dispute, waiver of privilege by former clients of a defendant law firm, the use of law of the case doctrine to object to a request for sanctions, specificity for a change in responding to a motion to compel on search terms, a unique ruling on custody and control of BYOD devices, and an expedited discovery request in a stolen cryptocurrency claim to identify a John Doe defendant. And just a reminder, we do welcome questions, and we'll try to get to as many as we can. And in response to the person who's already posed a question about slides, we will send out a copy of the slides after the presentation, so look for that too. So keep that in mind. And of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. It would be a cold day in Houston for us not to say that. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 27,200 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Our first case involved a claim of unpaid overtime pursuant to the Fair Labor Standards Act involving FedEx, where the court conditionally certified a collective of similarly situated individuals. Approximately 554 opt-in plaintiffs submitted consent forms affirming that they drove a vehicle with a gross vehicle weight rating under 10,001 pounds, worked more than 40 hours a week, and to the best of their knowledge, were not paid overtime for excess hours over 40 a week. That number dwindled to 483 opt-in plaintiffs at the time of this ruling. The plaintiffs asked FedEx to produce all scanner data, including time records and route information for the plaintiffs and each opt-in for about a 6-year period. FedEx initially objected to producing all scanner data, but later produced scanner data for about 204 opt-in plaintiffs who were designated by FedEx or the plaintiffs for individual discovery, which led to a motion to compel for the scanner data of all remaining opt-in plaintiffs. FedEx objected, stating the additional scanner data would not provide relevant information. The request for individualized information for all opt-ins wasn't appropriate in an FLSA collective action. The burden and cost of producing the scanner data outweighed its benefits and was disproportional to the needs of the case, and the GVWR was not included in the scanner data and is unduly burdensome to produce. In ruling on FedEx's objections, Massachusetts magistrate judge, easy for me to say, Catherine Robertson stated, FedEx ignores that plaintiffs contend that the actual data captured by the scanners is relevant to show that the drivers work more than 40 hours a week. The scanner data for opt-ins for whom this data has not been produced is likely to contain materially new information that is neither duplicative nor cumulative of the scanner data that was previously produced for a subset of opt-ins. She also stated in rejecting the cases used by FedEx to support its position, plaintiffs have adequately demonstrated the relevance of the scanner data. And she stated FedEx's claim that plaintiff's motion encompasses GVWR information for all opt-ins is simply inaccurate. Plaintiffs have acknowledged that the scanner data does not include GVWR information, and they are not moving to compel production of this information. So she granted the plaintiff's motion to compel and gave FedEx 30 days to produce the information, which is way more time than they normally get to make a delivery. So Tom, do you think FedEx's argument that the scanner data for all 483 current opt-ins was unreasonably cumulative or duplicative of the scanner data it produced for all 204 opt-ins was a case of throwing an objection against the wall, hoping it would stick, or was there any merit to that objection?
Yeah, I'm going to have to go with door number one on that one, Doug. I mean, the judge made several points in her opinion. You mentioned, you just pointed out one in the slide, that the new data it was likely to contain materially new information that was neither duplicative nor cumulative of the prior data. She also stated that FedEx was the single source for this information, and a single best source for this information, and that finally FedEx had not shown that producing this data would be unduly burdensome. They didn't use any figures to discuss why it would be burdensome. So for all of those reasons, she said point blank that plaintiffs have adequately demonstrated the relevance of the scanner data, end quote. So not a good objection, in my opinion.
Yeah, I agree. I mean, what could be more relevant than the scanner data that shows how many hours they actually worked, right? Hello. So yes. So Judge Peck, from a judicial perspective, how does discovery differ for a class or collective action case as opposed to when there isn't a certified class or collective?
All right. Well, the FLSA is different than the more common class action. In the typical class action, everybody on an airplane that crashed died, similarly situated, and then maybe you get to individualized damage determinations, maybe you don't. Fair Labor Standards Act cases really is just a way to combine many individual plaintiffs in the action, but each one has to prove their case and has to prove their damages, really has to show that they worked overtime. And the fact that employee A worked overtime, as shown through scanner data, doesn't mean that employee B worked that amount of overtime or worked any overtime or any of that. So I really don't understand FedEx's argument here, other than potentially their burden argument that they didn't really put any meat behind. If it's the issue is the additional scanner data for each individual opt-in plaintiff, they're entitled to that.
Yeah, absolutely, without a doubt. Well, great. I appreciate the differentiation of the FLSA actions. I did not know that. So, so one of the things, certainly, Mary, scanner data for opt-in plaintiffs is a unique form of ESI we don't typically see. So, what advice do you have for our audience regarding how to handle unusual forms of ESI in eDiscovery?
Well, the first thing, of course, is that data is data. And for these unusual forms of data, there's inputs and outputs, and then whatever happens in between. And there's opportunities for data to be saved down and become ESI at all three places. But with scanners or time cards, medical devices, cards, they're all likely to have an API, which is an application programming interface, which means the fields or columns or objects have some form of definition that you can see. Oftentimes, there are multiple sources of the data. The scanners, for example, likely upload their detail and then erase themselves so that they can accept more. And if detail records summarize, sometimes the detail itself might be erased. So you want to make sure that if you need that you have that preserved. Data in device data might look unreadable, but don't be surprised to see PII in it, like social security numbers, credit cards, phone numbers, and things of that nature. And one of the cases I had early in my career had some data like this. And what happened in between actually was really important, because basically the code was, if the worker didn't sign out for their break, the code signed them out. And so they would have to come back and sign in, and it looked like they were taking breaks. That was what the suit was about. So look at what goes on in between as well.
That's a great point, and great information. Question from the audience: what are some good examples of adequately demonstrating that carrying out a request would be unduly burdensome on a party? Actually, we'll have a really good example of that coming up here in a couple of cases. So we'll take a look at that, and that one will be a really good one that will illustrate how a party use metrics to do that. So great question, but we'll move on to the next case to keep on schedule at the moment. In which our next case is a bankruptcy court case, which involved a law firm defendant, K&F. K&F timely asserted attorney-client privilege in response to portions of the production request and provided privilege logs on a rolling basis as its review continued. In response, the plan trustee timely challenged the assertion of privilege on a variety of grounds. Over several months, the dispute was narrowed by the parties to 703 documents identified as challenged documents. In June of last year, the court established a protocol to resolve the privilege dispute where K&F was to file with the court a list identifying the name and last known address of each client that K&F represented in connection with the transactions referenced in the complaint, along with any retention agreement with respect to any and all former K&F clients and revised privilege logs identifying the former K&F clients involved in each of the challenged documents. The court directed that the plan trustee serve copies of the revised privilege logs and the protocols order on the identified former K&F clients on or before August 25th of last year, which they did. Any former K&F client that wished to assert a privilege with respect to the challenged documents had to file an objection to the relief sought in the motion to compel and serve the objection on counsel to the plan trustee by September 8th. Any former K&F client that filed an objection also had to appear at the adjourned hearing and was provided instructions on how to appear at that hearing via Zoom. So what happened? No former K&F client took either step to assert privilege. So the aptly named New York bankruptcy judge Alan Trust ruled that privilege was waived for the documents, stating, because K&F asserts the privilege, it bears the burden of establishing the elements of the privilege. The court does not need to determine if K&F established the first three elements of the privilege because it failed to establish the fourth, the element that requires that the privilege be both claimed and not waived, concluding the former K&F clients have waived attorney-client privilege in response to the plan trustee's discovery request for the challenged documents. K&F may not continue to stand on attorney-client privilege as a basis for declining to comply with the plan trustee's discovery request for the challenged documents, so he ordered K&F to produce them. So, Mary, I thought attorney-client privilege remained even after the attorney-client relationship ends. Should Judge Trust have required explicit waiver of privilege as opposed to simply waiving it for those who didn't respond?
Well, if he waited for an explicit waiver, he'd be waiting a long time because it seemed like he was screaming into a void. Nobody was responding to him, and so the privilege rests with the client, and it's great that the law firm acted on behalf of its clients. But when the clients were explicitly asked and served, so I mean, it went through the normal process, and then nobody piped up and said, yes, we'd like to keep this confidential. I mean, getting to withhold documents on the basis of privilege is actually, I mean, that's quite a thing. It's quite like to overuse the word. It is a privilege. It's not a right, evidently. So.
Sure, absolutely. So, Tom, could the law firm defendant have done anything different to protect attorney-client privilege for documents involving their former clients?
Well, yeah, a couple of things, and I think the judge did a good job of pointing them out in the opinion. I mean, basically, he said, "Look, if you're going to assert the privilege on behalf of your client," and his actual wording was this quote assertion of the privilege appears to have been based merely on K&F's assumption that its former clients would want the privilege asserted, rather than them having undertaken efforts to ascertain whether this is actually what their former clients wanted. So they needed to do some sort of an investigation and show that to the court, that they'd spoken with the clients, they discussed the privilege, and the clients wanted it asserted. Clients could, of course, appeared and asserted it themselves, and that's the second point the judge raised, which was, even if the privilege, and this is a quote, even if the privilege was properly asserted, the former clients waived that privilege by declining to respond to the protocol's order, end quote. So two things they could have done is talk to the clients and make a showing that the clients wanted to assert the privilege or wanted their former attorneys to assert it on their behalf. And then two, make sure they showed up at the hearing.
Yeah, absolutely. Seems like that would have if they had been maybe more proactive with their former clients, maybe they could have preserved privilege for some of those. So yeah, a very interesting case and a very interesting scenario in terms of waiver of privilege. So yeah, this was one of the more unique ones I've seen in this regard. I don't think I've ever covered a case where a court did this to determine whether those former clients wanted to preserve their privilege. So yeah, very interesting case. And we'll move on to the next case, which is an employment discrimination case where the defendant had previously filed a motion to compel after the plaintiff had produced only screenshot of emails in his possession related to whether the plaintiff signed or knew of the arbitration agreement, which the defendant contended were illegible and in black and white. Despite the defendant's assertion that the plaintiff had access to the original format emails, the court accepted the plaintiff's representation that he produced the documents he had in his possession and had no access to other versions of those documents. So the motion to compel was denied. But when the plaintiff was deposed, he made admissions that appeared to undercut his representations in response to the motion to compel. For example, he testified that his work emails were in his personal email account, but he didn't do a keyword search of his personal account. Rather, he scrolled to the dates covering his employment and manually looked for emails received around that time. He stated he didn't search his sent or deleted boxes and couldn't explain why his screenshotted emails were in black and white. He also stated that he had access to the full emails in his personal account even after he filed the lawsuit. So the defendant moved for sanctions against plaintiff for misrepresentations about the emails and sought an order compelling full and complete productions of those emails. Michigan Magistrate Judge Curtis Ivey rejected the plaintiff's contention that the court's conclusion that plaintiff produced all the documents over which he had possession is law of the case doctrine and cannot now be challenged, stated, defendant's motion does not implicate law of the case doctrine. Defendant is not challenging a prior ruling. Instead, it is arguing that facts discovered after the court's ruling cast doubt on plaintiff's representations to the court. The motion for sanctions is not a veiled appeal of the prior ruling. Judge Ivey also stated there's inconsistency between what plaintiff provided to his attorneys for production, his deposition testimony, and his affidavit. He also said it became clear at the hearing on this motion that plaintiff's counsel was never involved in the search of plaintiff's email, noting that counsel admitted that the plaintiff is a layperson not qualified to conduct discovery on them, and stated plaintiff's counsel is ordered to search plaintiff's entire personal email account, inbox, sent, and deleted email boxes for responsive emails. Counsel must then produce any such emails in their native format with entire emails downloaded to PDF and sent to defendant's counsel. He also ordered the plaintiff to pay defendant's costs in bringing this motion. So, Mary, some of the screenshots the plaintiff produced were illegible. Do you think that production of those could have been an attempt by the plaintiff to comply with the production request without really complying? Otherwise, what would be the point of producing them?
Well, as I read this case, this plaintiff reminds me of some of the potential 30B6 witnesses that got interviewed and rejected for past cases. For example, he said the plaintiff said he didn't look or he didn't do a keyword search, but he found the dates of his employment and he looked at the emails in between those dates. So but he didn't search for it. So anyway, I think it looked a little better, a little bit worse in terms of what he did. I also found it interesting. There was a complaint about everything being in black and white. And, when we see things printed in color, I think that, and it's germane to a case, that's unusual. Mm-hmm. That the attorney didn't assist with this very difficult communicator. I think that's probably at the heart of all of this.
Certainly. Yeah. Absolutely. And I think the fact that Judge Ivey called out plaintiff's counsel was notable. So, Tom, Judge Ivey, as I mentioned, noted that it became clear that plaintiff's counsel was never involved in the search of plaintiff's email. Should he have ordered plaintiff's counsel to share in paying the defendant's costs?
I would say yes, only because two factors here. One, as you pointed out in that last quote from the judge, they clearly knew the client wasn't up to the task. They were a lay person who wasn't in the best position to conduct a thorough search, et cetera, et cetera. But even further, even if they weren't qualified to do that, they still might have come up with the right answers, the right data, simply by happenstance, I suppose. But they didn't. As the court pointed out, quote, there is inconsistency between what plaintiff provided to his attorneys for production, his deposition testimony, and his affidavit. So the attorneys knew that there was something bad going on here, and I think should be held accountable for it.
Yeah, certainly seems like they dropped the ball at the very least. So one of the things interesting about this case was the plaintiff's claim of law of the case doctrine. So Judge Peck, for those in the audience who aren't familiar with it, what is law of the case doctrine, and when does it apply?
Essentially, it means that once the court has decided something, that's it. You might get a judge replaced and a new judge. You can't just say, Peck decided this before, but Peck is an idiot. You're the new judge. Redo it all. So whether same judge, different judge, or anything else, whatever the prior ruling is, it stays. The caveat to that, as Judge Ivey pointed out here, is that when there is new information, or occasionally when there is new case law from the circuit, or heaven forbid the Supremes, that could be a basis for revisiting issues. Here, the new information about what the plaintiff did or didn't do and all of that was a perfect reason to re-examine not the prior ruling, but the issue of whether there was spoliation. I just want to point out one other thing with what Tom was saying, and that is, while, as a now practicing lawyer, I hate to throw lawyers under the bus, but particularly where you've got a single plaintiff in an employment discrimination case, having an award of legal fees against the plaintiff might be a nice piece of paper to frame and put up on the wall, but would it ever be collectible? The lawyer is more apt to have some money in the bank.
Yeah, great point. It's very interesting. Obviously, we see lawyers allowing parties to do self-collection much more than they should. And this was one case where that party was ill-equipped to do it. So certainly notable there. Getting some great questions. Also, will there be a recording available? Yes, there will be. When we send out an email after the webinar, you'll get a link to both the recording and the slides, so you can look for that. And we have some other great questions we will circle back to toward the end of the webcast. So in the meantime, we'll move on to try to get through these cases and circle back. Speaking of questions, the question on a good example of adequately demonstrating that carrying out a request would be unduly burdensome on a party. This is a great case that serves as a great example. And it's something involving something we haven't seen a lot of, which is the use of metrics in objecting to discovery requests. In this alleged misappropriation of trade secrets case, the plaintiff originally requested defendant conduct an ESI search of various devices for 13 individuals by applying 99 different search terms to the sources of data. Defendant conducted searches and produced documents using 92 of those terms, but contended that the remaining 7 search terms dramatically increased the volume of ESI to be reviewed. Specifically, they said the search terms were estimated to result in over 42,000 documents for review, that it would cost as much as $4,275 for processing and applying analytics, and they provided a high-end cost estimate of over $114,000 for 600 hours of attorney time to review the documents. More on that estimate in a bit. The plaintiff did not dispute any of these estimates, but instead argued that these additional expenses were proportional to the needs of the case because the search terms were only being pulled from a discrete 6-month period. South Dakota District Judge Karen Schreier used the 7 good cause factors under which discovery can be ordered, even if the ESI is not reasonably accessible. Among the factors were the likelihood of finding relevant responsive information that cannot be obtained from other more easily accessed sources, and predictions as to the importance and usefulness of the further information, where she said Crossroads and its ESI vendor assert that the relevancy rate of these search terms will be incredibly low. Specifically, they've used a continuous active learning model to determine the relevancy of previous searched. This model has deemed 7% of its total ESI review as relevant, with the last 2,000 documents reviewed by this model have not exceeded a relevancy rate of 5%. And Crossroads expects further review of ESI to have a similarly low rate of relevance. Jim Hawk does not dispute these figures. Instead, it argues that Crossroads can't represent with any degree of certainty that there will be no discoverable documents produced from these searches. Jim Hawk then provides one-sentence explanations for how each search term corresponds with facts alleged in this case. These rebuttals do not persuade the court of the likelihood of finding information important to the case. Judge Schreier stated in denying the motion on the 7 ESI search terms, the low relevancy rate of current ESI and Jim Hawk's failure to show a heightened likelihood that new and relevant information may be discovered using the search terms in dispute is the most important good cause factor here. The substantial burden and expense required to produce the sought ESI documents cannot be justified by this low likelihood. Thus, Jim Hawk fails to show good cause for the discovery of documents that are not reasonably accessible. So, Tom, the defendant was able to rely on review they'd already completed using CAL to estimate the prevalence of the additional search results. What could they have done to illustrate that it would be a low prevalence if they hadn't done any review yet?
Well, it's going to be difficult. I mean, one thing they could try to do is to see if they met any of the 7 good cause factors, and perhaps bring in an expert to testify about similar types of data, or if they themselves had been involved in a similar case with similar data, to say, here is what we found. That's a stretch. I would think they'd have to do some sort of limited review to come up with some metrics.
Sure. I mean, yeah, like a sample, right? I mean,
you're reading my mind. Are you looking over my shoulder at my notes? It says right here, do a sample, and maybe even a small enough. No. I mean, I think that's it. That, something we often overlook in these sorts of big data cases is do a sample, whether it's a search or sending data on a protocol exchange, whatever. And perhaps even do a small enough sample that they could do a manual search and say, look, we did it this way. And, with CAL, we can go through all of this. And that's, manual would cost this much. CAL is still going to be expensive. And perhaps as part of the sample, run some sort of a quick analytics, maybe even some clustering or concept searching, just to try to get a handle on it. But I think that's going to be the answer, is some sort of a small sample to at least base some figures on.
Yeah, agreed. And I think that, you could do a statistical sample that would not be more than a few hundred documents to get a sense. So at least that could be a way of doing it if you didn't have that data. So Judge Peck, we rarely see cases where parties provide such detailed analysis and metrics to support their objections. So why do you think more parties don't do this? Is it because many of them just don't know how to perform a statistical sample?
That is certainly part of it. What people went to law school because they were promised that they wouldn't have to deal with math, right. And now they're being asked to deal with math. But the other factor may be the lack of adequate data in order to do statistical analysis. Here they had the documents they had already reviewed, and that gave them a lot of information. Often the dispute is before the court when there isn't that information available from the current case. Maybe one could use data from a prior case of that client, query whether enough clients keep that sort of metrics from case to case. But it is certainly one of the key factors that a court needs to decide this. The other thing that would come out of the sampling approach that Doug, you and Tom were talking about, and you obviously all read my notes also because I was going to talk about sampling. We're all on the same page here. But the other question in all of this is, there may be a lot of data that has to be searched, but is it relevant? Is the 7% or 5% or whatever is going to come up here something that is just more of the same and isn't going to advance the case? Or is there the possibility that there will be, the smoking gun documents or the key documents that will decide the case? And that's got to be balanced in as well.
Judge,
No.
I can't resist saying, I'm sorry to interrupt, Doug,
Go
but
ahead.
in terms of sampling, are you saying that there may be a 7% solution here?
Oh.
Very good, Tom.
We're not on our prep discussion. I was talking with my friends here about the book, The 7% Solution by Nick Meyer, which involved Sherlock Holmes getting together with Sigmund Freud.
Very, very, very nicely played, Tom. Indeed. So one thing I noted about the estimate, Mary, the defendant estimated 600 hours at a cost of over $114,000 to review 42,000 documents, which seems like a linear review estimate to me. So is that a bait and switch since they were demonstrated to be using a CAL approach?
Well, I don't think we need Sherlock Holmes to tell us the answer to this one. It certainly does look like a linear review and a very, I would say, relaxed linear review. That's quite a lot of coin for 600 hours, and but the 5 to 7% relevancy, that those numbers really intrigued me, because if the whole collection was 7% relevant, to say 5% is, the review's over just doesn't seem right to me. I don't know what you thought about that.
That was certainly interesting as well. It certainly seems like they used one set of numbers to kind of provide estimates, but the approach wouldn't necessarily have led to that. So I was a little perplexed by their thinking there as well. But certainly, I guess they figured they'll put forth the most the most highest estimate they could possibly use. And run with that. So
yeah. They did say it was a high end estimate.
Indeed.
And they had a number for the analytics, that they were charging for the analytics somewhere around $5,000 or something like that. Mm-hmm. So yeah, those numbers look like attorney time.
Right. They sure do. And it absolutely is very interesting. But I give them kudos for a lot of people will talk about the number of documents that may be retrieved from search terms, but it's difficult for courts to say what if they could be highly relevant. A high number of documents still is a high number of documents that has to be reviewed and produced. But obviously, in this case, they provided that low prevalence, which helped in that decision. So hopefully, for the person who asked the question about a great example of demonstrating undue burdensome, this is a pretty good example. In fact, one of the best we've seen in a while. Got a couple other questions on this case. One is that It appears the court conflated proportionality under Rule 26b1 with not reasonably accessible under Rule 26b2b. How do we get courts to understand the difference?
Yeah, I mean, first I would say that, in my view, clearly was the wrong analysis. Not reasonably accessible is not the same as proportionality. It's going to cost too much, so it's not reasonably accessible. Not reasonably accessible is, a rarity, but, maybe it's the server that had the data hadn't been used in 10 years and couldn't reasonably or easily be restored, etc. The other thing, in defense of the judge, did the lawyers present it under the wrong standard and the judge just sort of blindly went along with where they led her down the garden path, or did the judge come up with this idea herself? Hopefully the former and not the latter, but as the commenter was clear, and I agree, wrong standard being applied here.
Yeah, that's something that was a great point by the audience member there, and yeah, a great assessment. Here's another question tying to this case: will the advent of exponentially growing AI help in assessing probabilities of relevance in the future? Well, I think we could argue they already do. The key is, are people using them? Any thoughts from the panel on that question?
Yeah, I'm sure as the AI gets better, it will help, but only if lawyers use it. I mean, this is one of the few cases where the party was using TAR, continuous active learning. In many, many cases, we're dealing with the old-fashioned fights about keywords.
Yeah, absolutely. And certainly the State of the Industry report that eDiscovery Today released earlier this month shows there's still a lot of lawyers who aren't using, or legal professionals for that matter, who aren't using TAR in most of their cases. And most legal professionals, even those who fill out an eDiscovery survey, don't still use it most of the time. So we have a ways to go there. Great comments, great questions from the audience, and we'll move on to the next case. This next case goes way back to last March, and I discovered it based on a mention by Kelly Twigger in her thought leader comments to the State of the Industry report I just mentioned. So in this antitrust pork price fixing class action, the plaintiffs originally requested that defendant preserve data from personal cell phones of 5 company executives, but that eventually ballooned to 30 custodians. The defendant objected that it did not have possession, custody, or control of the custodian's personal cell phone data for their BYOD devices, even though they had a corporate BYOD policy that required employees to install software on their devices that gave the defendant the ability to remotely wipe their device upon a departure. Notably, while disagreeing with the defendant, the plaintiffs also subpoenaed the custodians directly for the information based on the scope you see in that second bullet point there today. Noting some courts in the district interpreted control to mean the legal right to obtain the documents, while others have held that control may also include the practical ability to obtain the documents, Minnesota Magistrate Judge Hildy Balbier stated, "The court need not choose between the legal right and practical ability standard because, for the reasons discussed below, it finds that, regardless of the standard applied, plaintiffs have not shown that Hormel has control over text messages on the personally owned phones of its employees. The Sedona Conference has taken the position that an employer does not legally control personal text messages despite a BYOD policy when the policy does not assert employer ownership over the text, and the employer cannot legally demand access to the texts. So she denied the plaintiff's motion to request the text messages from the defendant. However, it was a different story regarding the custodian subpoenas, where Judge Balbier stated that, aside from one custodian that you see there on the slide, who stated unequivocally that she never used her personal cell phones for work-related communications, the court cannot conclude from the responses that adequate steps were taken to describe to the custodians what kind of communications might be relevant and responsive information in the context of this complex litigation. So she ordered the custodians other than Chenoweth to search for and produce relevant text messages within a modified scope and subject to a modified search protocol, which is detailed in the blog post, and ordered all of them, including Chenoweth, to preserve all text message data for a period of over 10 years. So, Judge Peck, do you agree with the ruling to deny production of the text messages by Hormel, and do you agree that the Sedona Conference commentary on BYOD supports that ruling?
Sort of, or I guess I would say it depends.
Oh, there we go.
Look, I mean, I suspect most of the audience knows, but just for a bit of legal background, there are two principal tests that courts use to determine possession, custody, or control. In the Second Circuit, where I practiced all my life, it is the practical ability standard. And Judge Browbeard, and analyzed that as well, and said that the employer did not have the practical ability to get the information from the employees. I'm a little dubious on that, or at a minimum, I probably would have said if this case were in front of me in the Southern District, that they have to at least ask and see which of the employees will cooperate and which won't. The other test predominantly used in the Ninth Circuit is the legal right test. And clearly, under this BYOD policy of Hormel did not have the legal right to get texts from employee-owned phones. The other circuits, as Judge Browbeard noted, either don't have a rule or different district judges within the circuit use whichever of those two standards they believe to be right. So, I would probably have pushed Hormel somewhat more than the judge did. On the other hand, what did Hormel gain? For most of these folks, if they are current employees, I would bet that Hormel will either be representing them as they now have to go search for this data, or will be paying for independent counsel to be representing them. It's different if you've got employees outside the jurisdiction and you've got GDPR or other privacy issues. Domestically, all a company may be buying itself is, distracting litigation and non-party subpoenas with its employees.
Yeah, absolutely. I think it was something like 17 out of the 30 were current employees. So certainly that certainly about 2/3 roughly. So definitely very interesting. A long case, but an interesting case, which is why we circled back to it. So Mary, do you think a ruling like this will cause organizations to limit the scope of their BYOD policies to avoid having to perform discovery on employee mobile devices?
Well, I think companies, especially unregulated companies, I don't think the financial services companies will do this, but I think other companies may. And it's an interesting application of mobile device management that there's no ability to inspect in this case, but it's not a backup solution. It's just a wiping security solution. So I think that's quite interesting, and other organizations may go down that road to just to not have access to the texts.
Yeah, I wonder if they would do that. Certainly, I can see it. Go ahead,
Doug. If I could expand on that, and I'm not giving legal advice, you can hire me to do that. But the issue for companies is, do they want to be able to throw their hands up and say, well, we can wipe, but we can't get texts or other things that are not part of the mobile device management control? Or do they want to say, as a condition of employment and being paid, the X that you're being paid for use of your own phone under BYOD, you agree in advance, at least while you're employed, to give the company access to the quote unquote personal side of your device in the event of litigation or other legitimate need for that. It's a tough question, but companies should be wrestling with that as they set or reset their BYOD policies.
Yeah, I couldn't agree more. So certainly the plaintiffs might have been up a creek on this case, Tom, if they hadn't had the foresight to go ahead and request the text messages from the custodians themselves, even though Judge Balbier hadn't yet ruled on whether Hormel had to produce them. Are you surprised that they had that foresight?
No, for a couple of reasons. One, as you say, maybe they'd been up this creek before, and didn't want to go up the creek again, and so they knew to do that. Two, the first paragraph of your screenshot here on the slide talks about the fact that they've been involved in negotiations prior to this. So apparently there were some sort of, early case negotiations, early disclosure / cooperation between the parties to try to resolve this. And maybe that gave them some sort of a basis to think that they could get these if they made the request. Maybe they thought they could, slip the high inside fastball past them. I don't know. But third, you also noted that the court said, or made reference to the fact that some courts in the district had interpreted control one way and other courts had interpreted control another way. So obviously this has been an item of discussion in other litigations in this district for a while now. Maybe they had some inkling from some prior case decisions of how Judge Balbier was going to rule. So they went ahead and did it. So I can't say I'm overly surprised given what we're reading here in this case.
One other point to jump in.
Sure.
As the Sedona commentary on Rule 45 summarizes the law, merely telling non-parties, aka the employees, please preserve, is not worth the paper it's written on. Absent a subpoena, they can do what they want. So having served the subpoena was certainly a protective way to make sure that the data did not suddenly go away.
Right.
Yeah, great point, especially when we're talking such a long period of data too. So yeah, very interesting case here. A couple of questions. Will BYOD still be a thing in 2023? Well, I would say it already is. And I believe, and I don't remember the stats off the top of my head, I think the majority of companies are more BYOD oriented than company owned device oriented, at least based on stats that I've seen. So I certainly think it's not going anywhere. Don't know if any of you all agree with that, disagree with that, but certainly it's going to still be plenty prevalent in 2023 and beyond, as I can see. Also a question about how you can get the state of the industry report. I assume that's the study reference you were talking about. Simple, subscribe to eDiscovery Today, email subscribe to eDiscovery Today at eDiscoverytoday.com, all one word, no dashes, and you'll get that report and all reports we provide for free. So just simply subscribe and you'll get it. And I promise I didn't pay the person to ask that question. So there we go. And on to our last case, because we are starting to run short of time. And now for something completely different, as Monty Python would say. Here's a case where the defendant was alleged to have convinced the plaintiff and her son to fund a cryptocurrency wallet with $1.4 million, which was then allegedly stolen by the unidentified defendant. The court had previously granted the plaintiff's motion for a temporary restraining order, after which the plaintiff proceeded to file a motion for an expedited discovery request to several cryptocurrency exchanges for all documents regarding, reflecting, recording, or memorializing account opening and closing, including John Doe's actual legal name, all proofs of identification, date of birth, social security number, telephone number, electronic mail address, residential mailing address, etc., as well as a variety of other requests regarding transactions, correspondence, and so forth. In considering the motion for expedited discovery, California District Judge Dale Draws, or Drost, I'm not sure which, the court stated the court finds that good cause supports the plaintiff's request for leave to take expedited discovery to ascertain identifying information with respect to defendant John Doe in order to facilitate service of this action. The temporary restraining order and plaintiff's anticipated motion for preliminary injunction. Here, plaintiff recounts the use of blockchain analytics to trace the path of her stolen assets and identified a number of cryptocurrency wallet addresses at the exchanges to which her assets had been transferred without her consent. Judge Strauss added, the conversations between the defendant, plaintiff, and plaintiff's son indicate that John Doe's identity as the account holder is likely already known or ascertainable. Furthermore, as this court concluded in its June 7, 2022 order issuing a temporary restraining order, plaintiff has shown that she is likely to succeed on the merits of her claims brought in this action, and in doing so, she has also demonstrated that the action can withstand a motion to dismiss. But Judge Strauss also denied much of the plaintiff's expedited discovery request, finding that plaintiff had not narrowly tailored all of her proposed discovery requests to the cryptocurrency exchanges or provided good cause for the authorizing of expedited discovery beyond certain specific identifying information about the Doe defendant. As a result, Judge Strauss granted the motion to issue a discovery request to cryptocurrency exchanges in part, seeking information about defendant John Doe consisting of legal name, street address, telephone number, and email address, but not Social Security number. So, Mary, with the bankruptcy of FTX and subsequent litigation, as well as other cryptocurrency failures, it seems as though discovery of cryptocurrency wallets and blockchain transactions is going to become more commonplace. Do you agree? And if so, what recommendations do you have for our audience on how to prepare for blockchain discovery?
Well, I think there are several areas to look into. One is to refresh yourself on structured data generally. We typically are working with the unstructured, more Word, emails, those text messages, those kind of things. Also, get to know your forensic accountant. If you don't have one in your network, you've got to get one, and locate some crypto experts in something called what you were talking about, Doug, from the case blockchain analytics, so that you can trace the movement along the blockchain. Also, refreshes on Rule 45 that we talked about earlier and non-party custodians. Certainly in terms of banking and funding accounts, you've got know your customer laws, anti-money laundering laws. So there are indications of identity. So to refresh yourself on that. Also, wallets and keys, and what's possible with the different kinds of wallets, and what's possible with the different approaches to holding keys, whether the user has them, or whether the platform has them, or the custodian has them. It's important to get a sense for how all of this works.
Yeah, absolutely. It's coming, and be prepared for it. Those are all great recommendations. So, Tom, this is a civil case, but based on what the plaintiff has alleged, it seems like it could eventually turn into a criminal case as well. So, what advice do you have for our audience on how to support both?
Do not try this at home. If you think there's a chance of a criminal case, get a criminal lawyer involved, criminal defense lawyer involved. And I've had several cases where clients, law firms of clients, have asked me about this because of the work that I do with the federal defenders, and I've told them, go talk to a criminal defense attorney. If you have one in your firm, get them involved. If you don't, go talk to somebody outside the firm, and whether they're going to be separately retained or co-counsel, whatever. But you can be the best civil eDiscovery attorney on your block, but you're going to be 4 feet tall in the deep end of the pool once the U.S. attorney and a criminal investigative agency, especially if the U.S. government gets involved. To that end, make sure, if you think that's going to happen, that you back up and make copies of every device that your client has come into contact with. when a subpoena or a warrant is served, they will seize everything, not just at your office, but at your house. And I mean everything: your wife's computer, your children's computers, laptops, cell phones, Game Boys. If it's an electronic device that can store data, it's probably within the scope of the search warrant and the seizure, and they'll take it. So make sure that's all backed up. And then finally, and I got, as always, when I get asked these questions, I consulted with my old friend Russell Aoki. He's the national coordinating discovery attorney for the federal defenders, in addition to his own civil practice in white collar defense in Seattle. And I've had the privilege of working with him for many, many years, more years than either one of us want to talk about. But he also suggested that you consult an ethics attorney regarding your activities, you, the attorney, to make sure that you're taking all the proper steps and protecting yourself, because you just want to make sure that everything you're doing, given your unfamiliarity with criminal defense work and criminal discovery work, you want to make sure that you're crossing those T's and dotting those I's. So thanks to Russ for that tip.
Yeah, and all great recommendations and great suggestions there, Tom. We do recognize we're a little past the top of the hour. I'm going to ask Judge Peck a question about this case, and then we'll try to address as many of the excellent questions that you all have submitted as we can. So, Judge Peck, did you ever have any cases involving an anonymous John Doe defendant, and what can a party do to pursue identifying such a defendant in federal civil court?
Yes. And I would say there are two types of John Doe defendants. One is where there are other defendants who you know. So a typical excessive force case where the plaintiff says, I'm suing the NYPD and Officer Moran for beating the heck out of me, but John Does 1 through 5 were also there kicking and punching me, but I don't know who they are. And then you'll go through discovery from the police department and the named officer to find out who else was there. This sort of case, I did have a few where the only defendant was a John Doe or indeed an IP address. And they were copyright infringement cases, amusingly, of X-rated videos, where the complaint is, yes, it's an X-rated video, but I've got a copyright on it, and this IP address downloaded my movie, and they have to pay for that privilege, and they didn't. And then you go into discovery about the IP address and how you find that, and then you find out it's the grandmother's computer, and she probably wasn't watching the porn, but somebody who lived with her was, and et cetera, et cetera. But that's in the interest of time, I'll stop there.
All right. Yeah. Great example. I believe I've touched on a case or two in coverage over the years in that regard. So I will flip to the contacts page, and we do have a date for our next case law webinar. February 14th is for lovers of case law. So join us on Valentine's Day, where we'll have new cases to discuss. But first, we're going to try to get to as many of the leftover questions as we can, and we do appreciate all of them. First of all, to the person who said they logged on late, don't let it happen again. We understand you. Just kidding. The recording of the webcast will not only be available on the EDRM site, but you will receive an email later, probably later today or tomorrow, with a link to the recording as well. So rest assured, you'll be able to catch the entire recording of it. So back to some of the questions from earlier. How would an entity preserve scanner ESI in accord with Rule 37E? Does anybody have any thoughts about that one?
Well, I do. I think you need an intermediate device or an intermediate resting place for the data on the scanner. The scanners have a limited storage, and they certainly upload in this case, to the FedEx site, but we don't know if the detail gets overwritten or aggregated. So if you want all the detail records, you need to have, you can use a thumb drive, an external hard drive, or something like that, and make sure that you have a stream of data from those scanners, either when it's uploading to the FedEx site, or it would be kind of, I would think burdensome to do it out in the field, certainly.
Yeah, that's yeah, absolutely. Another question: should you explicitly ask clients as they are leaving the firm if they want to waive privilege going forward, like a reverse engagement letter? Thoughts about that?
I mean, that's a thought. The better question perhaps is, once the client becomes a former client, should you be retaining their data or returning it to them? Now, to a certain extent, law firms have to keep certain data to protect themselves in case of a malpractice suit down the road. I'm not sure that clients are going to waive privilege when they leave you, depending on the situation. So it's an interesting thought, but I don't know that it's practical.
Yeah, that makes sense to me. And then a question, what about ephemeral messaging? So I'm going to assume they're asking here, what about ephemeral messaging? Does it complicate BYOD? Thoughts about that question?
No, that wouldn't do that, would it? Complicated?
Well, ephemeral messaging is complicated, period. I don't know if it necessarily is more complicated with or without BYOD, because it has its own complications, but certainly something to note there. I think, obviously, if you can't get control of the device, and you have a duty to provide, of course, these messaging apps are not just available necessarily on the device. So something to think about there. But any other thoughts about that one?
No,
right.
I guess the only additional point is, what is the BYOD policy?
Yeah.
And, is the employee allowed to use disappearing messaging apps or other things for work-related communications as opposed to on the personal side?
And how do you monitor that? How do you regulate that as an employer, right?
Sure. Yeah, absolutely. Yeah, I think it's complicated in any scenario, for sure. So I will. I'll say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. Thank all of you for attending. I'll turn it back over to you, Mary. There are two questions left that look like they might be EDRM questions related to the webinar. So maybe you want to address those as you close this out.
Oh, thanks, Doug. Yes. So one question is, will EDRM ever add auto captioning to make its webinars more accessible? And thank you for that question. We'll bring that back to BrightTalk, our platform, and see where they are in terms of doing that. And we'll reach out separately. Thank you. And the last question is, how do I get a CEU certificate of attendance? And you can get a certificate of attendance for any of the webinars you've attended on the EDRM BrightTalk channel. It is in your BrightTalk feed of recently viewed webinars. If you pop that open, you'll be able to download a certificate of attendance for any of the webinars that you've attended. And with that, we thank you, Doug, for this wonderful webinar, for anchoring. Thank you to Tom O'Connor and the Honorable Judge Peck for this insightful presentation. Don't forget to register. The paperclip has got next month's webinar. It's got tomorrow's webinar, or not tomorrow, the next week's webinar. And it's got links so that you can reach Doug, Judge Peck, and Tom O'Connor. So we thank you for your kind attention and look forward to seeing you again on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks, everyone.